Welcome to Hall on Estates. I'm Doreen So.
And I'm Mohena Singh.
You are listening to episode number 642. Today we're going to be discussing a case from the Court of Appeal. It's very recent. It's from this year, 2022, and it's called Walters and Walters. And it's a case where the Court of Appeal has to weigh in on how trustees have exercised their absolute discretion under a will as it relates to a life interest beneficiary and how much capital to encroach on this beneficiary's behalf. And this is always a hard button issue, this idea of you have absolute discretion, but what are the boundaries to this so-called absolute discretion, and what's the role of the courts in these cases? Should there be a disagreement between the estate trustees and the beneficiaries, which obviously is quite often the case. Mohena, do you want to take us through the facts in this decision?
Sure. So in this case, the deceased was survived by her husband and her children. So the will left the husband, Gerald, a life interest in the estate, and then left the residue of the estate to the children. So the will specifically said that the testator wishes to advise my trustees that my husband's comfort and welfare are my first consideration, and for this reason, it is my desire that my trustees exercise their powers to encroach on the capital in a manner which will ensure his comfort and well-being. So those were the exact words from the will. And the children, as mentioned, were the trustees. So Gerald, the husband, asked the trustees to encroach on the capital of the trust to pay for his living expenses. The trustees mistrusted their father, and along with the proprietor of the residence in which he was living in, and so they did not want to pay him the amount he requested. So then Gerald applied for an order that the trustees provide him with financial assistance. The application judge granted Gerald's request and ordered the trustees to pay him the sum that he was asking for. So initially, when Gerald asked for financial assistance, the trustees requested financial disclosure and receipts of expenses. And according to them, not enough information was provided. So therefore, the trustees had chosen to give him an amount that was not enough in Gerald's eyes. So from the material file, the application judge found that the trustees did not like or trust their father. And the judge found that the trustees were being influenced in their decision-making by extraneous matters, such as their distrust of the proprietor of the home where Gerald resided. So on appeal, the trustees argued that the application judge erred in substituting her discretion for that of the trustees with respect to the encroachment on capital.
Great. That's a great summary of the facts. Thanks, Mohena. Yeah, because, when you have a beneficiary, who has like the entire life interest during their lifetime, and they're entitled to capital so long as the trustees are willing to give the beneficiary that capital. How is the trustee supposed to actually go through that decision-making process? What is an appropriate decision-making process, and what is not, to the extent in which it is actually just so unreasonable and that the court would actually intervene. So this is actually a really great case that goes through a very thorough summary of all the cases that have come through in the past, where the courts have looked at these similar issues in the past. And we really do start with a basic starting point where in a trust relationship, the trustees have a fiduciary duty to its beneficiaries. And where the court fits in all of this is that the courts are still have to supervise the administration of trust. It's not just that, with this great power and responsibility, they can actually just do absolutely anything that they want with it because they have this quote unquote absolute discretion. But at the same time, the courts are still limited to the settler didn't name Justice so-and-so, the trustee, they still name these individuals to make this decision. So where's the balancing act? And that balancing act is really still that the discretionary decisions of a trustee is not to be substituted by the court's decision just because, that particular justice or even panel of justices would have decided differently. The analysis is really, did the trustees take an improper analysis to the beneficiary's request? Did they have these extraneous things in mind that would actually kind of call into question the ultimate decision that was made? And, all of the things that you've mentioned in your summary of the facts about, like the kids' distrust of their father, their dislike of him as a person, this decision is very clear that your dislike of a beneficiary, however you may personally feel about the individual, that is certainly an extraneous matter that really shouldn't be part of your consideration, because you are held to like such a high standard as a fiduciary to act in good faith and to act in actually utmost good faith. So you're really supposed to put your personal feelings aside. But Mohena, do you want to take us through like sort of like the first step in terms of like what the court says is the starting point for estate trustees?
Yeah, sure. So as you mentioned, a court will not interfere with the exercise of a trustee's absolute discretion unless the trustee exercised that discretion with malefides. And that doesn't have to be just fraud. It can be more. And you've described in this case, the extraneous factor was the dislike of the trustee. So what the court really said was that they wouldn't intervene unless the decision is so unreasonable that no honest or fair dealing trustee could have come to that decision, or that the trustees have taken into account considerations which are irrelevant to the discretionary decision they had to make, or the trustees, in having done nothing, cannot show that they gave proper consideration to whether they ought to exercise the discretion.
Right. And so the court does actually help us a little bit in advising trustees in terms of like what our clients' roadmaps should be if they're in this role. And that very first step is actually the intention of the testator, as you see it in the wording of the will and the surrounding circumstances in which the will was made. So here, in this case, you have a will that actually gives guidance to the trustees, right? It says they have to take into account the father's comfort and welfare. And so, in terms of like our request where the father is asking for money sort of like for his home, that does seem to come quite close into the territory of his comfort and welfare, right? It's where he lives. Kind of seems like maybe he should feel comfortable in his living space. So that's kind of the starting point. And as I was saying before, dislike is certainly something that is extraneous, it's too personal, it should be parked aside. But it's actually interesting in this case that the trial judge found that the distrust was also an extraneous matter. But here, by the time it gets to the Court of Appeal and it's before the panel did say like the distrust in this particular instance was relevant and to some extent like justified by these estate trustees, because what they had a distrust over was actually the invoices that were provided by the father. So like the father, in asking for money for his house, provided for, gave them these invoices from a contractor. And when they spoke to there was evidence before the court from this contractor that perhaps like these invoices were actually inflated, sort of like bumped up so that more money would like go to the father and eventually into, I suppose, like this contractor's like pocket. And the trustees knew about that. And that's why they sort of like had a distrust over like the request. The Court of Appeal thought like, okay, well, in this particular case, under these circumstances, it is fair to kind of question what kind of bills are being like submitted for payment. And the Court of Appeal still said it was reasonable for trustees to ask the beneficiary to get some sense of their own financial circumstances, unless the will clearly says, don't ask. This is not about how much money the beneficiary has. So when it doesn't say that, trustees are justified to some extent to sort of do a little bit due diligence just to see like, okay, well, how much can you personally afford before we consider how much to give you out of this trust. And that's going to come out of the pockets of somebody else, right? Anytime you give money to someone who has a life interest, it comes out of the pockets of like the remaining beneficiaries. So, if in a scenario where this father is actually like extraordinarily wealthy, like say he has $10 million, but the estate actually only has $500,000, should the same like millionaire still submit bills for his house to like a $500,000 estate for the millionaire's welfare and comfort or not? That is where like say like I think like a little bit of that balancing act goes to. But again, the court of appeal is still very like balanced in saying like this doesn't mean you get to grill the beneficiaries either, right? Like you just have to do perhaps enough due diligence to like make a reasonable decision on good faith that actually like allows you to like balance the interests like on both sides. And ultimately like the court of appeal really found that even though the distrust may have been like sort of like justified and relevant under the circumstances, there was still not enough to overturn the trial judge's decision. And at the end of the day, because it really did seem like the no was given on the basis of like say a dislike based on the welfare and comfort of like this father, he should have at least like some funds for his house. The original judgment was upheld. I think there was like just like a small tweak, but ultimately the court did end up substituting the decision of these trustees. So like this is a really good case, I think, for everybody to just sort of reread, keep in mind the sort of like this is day summary of like, the law in the past, and this is what the court of appeal is now saying. This is how the analysis should go. So I think this concludes our podcast. Until next time, I want to thank you for listening. I'm Doreen So.
And I'm Mohena Singh.
Should you have any questions, please email us at info@hollandhealth.com or contact us through the webpage on our website. Thanks.
Thanks, Doreen.